From Lina Bensman and Tom Kessler. Lina is a litigation partner at Cleary, Gottlieb, Steen, and Hamilton, LLP. She has acted as counsel to financial institutions and multinational corporations, as well as individual clients, in a variety of securities and other commercial litigation matters before federal and state courts. Tom is also an associate, Tom is an associate at Cleary, Gottlieb, Steen, and Hamilton, and has represented a wide variety of clients in state and federal courts, including debtors and creditors and bankruptcy proceedings, numerous other securities litigations. And I will also say on a personal note that Lina and Tom represented plaintiffs, including myself, in the Jonah trial, which they'll be addressing today, and I can attest firsthand to their deep personal commitment to these topics. It's incredibly heartening to see such a convergence of professional power and personal passion. And Tom and Lina really exemplify that.
Hi, everybody. As Michael said, my name is Tom Kessler. I'm an associate at Cleary Gottlieb here in New York. We are here to talk about the two parts, really. First, the Ferguson v. Jonah litigation, which started all the way back in 2012. And if you can believe it, is continuing in at least some part through until today, and which was a brainchild of the Southern Poverty Law Center, and really became the first case in American history that litigated to a jury trial whether or not a gay to straight conversion therapy organization could be liable for claiming that it could convert people from gay to straight, and selling them essentially what we thought of as snake oil, selling them the lie of conversion therapy. Then we're going to talk a little bit more broadly about the concept of attacking conversion therapy through litigation, how that works, what its goals are, what its challenges can be, and how it works hand in hand with other efforts to combat conversion therapy, including legislative efforts, and really more broad, sort of tone-changing community outreach, less court, less legislative focused efforts, and more community-based. All right, Lina, I was vamping, and I'm now going to throw it to you.
I always really struggle with where to start when I talk about this case, because in many ways, the story of Jonah begins with Arthur Goldberg leaving federal prison where he was serving time because he was a convicted felon and fraudster, and finding out that his son was gay, and then founding an organization filled with hate to try and keep other gay children in the closet. That's one way to start the story. But in many ways, it feels like it does a disservice to the fuller story, because I think that fuller story starts with vulnerable young gay men and bisexual men in communities where they are made to feel unwelcome and kept in ignorance of what it means for them to experience homosexual desire, where they are subjected to a lot of rejection and fear, doing something that I think is incredibly brave, which is reaching out for help. And unfortunately, reaching out to the wrong person, often in the case of Ferguson v. Jonah, personally Arthur Goldberg, and what happens to them next. And that itself is situated in a larger story, which is that going back for actually generations, there has been medicalization of homosexuality, the treatment of homosexual desire as deviant or as somehow an illness or as something that requires treatment or correction, either medically or psychiatrically. And that long history certainly predates Jonah, and it predates the particular young men whom Jonah victimized, which is kind of a long way of saying that I don't know where to start. I'm just going to pick somewhere, but I hope that wherever I pick won't make anybody feel silenced or made invisible. But the bottom line is that Jonah, an organization founded on the basis of hate by vicious fraudsters, took advantage of vulnerable young people who had very few options, or often I think pretty accurately felt they had no options and nowhere to turn. And Jonah would advertise in synagogues, religious institutions of education, in religious neighborhoods. Their sort of prime market for their clients was the Jewish community in Brooklyn and in the larger tri-state area in New York. So they were looking for people who had a deep faith commitment and were in communities where there was not necessarily as much openness about sexuality. They might not see anybody who was openly gay in their communities or homes. And there were these very heteronormative expectations for them. And they would see a pamphlet or an ad in a newspaper, or they would go to a rabbi and they would be steered to Jonah. And the promise that Jonah made was that it could change you from gay to straight. And ironically, for all that, Jonah was really preying upon a religious community principally, not exclusively, not all their clients were even Jewish, but principally, that was a huge source for them clients. Ironically, despite this focus, Jonah was medicalizing its claims. So it would give you a percentage. It would say you have a 75% chance, you have a 66% chance to be cured, to go from gay to straight. And they created this fake institute called the Jonah Institute for Global Affirmation, and they claimed that it did research and tried to make it sound like there was really science behind what they were doing. So it was this kind of two-pronged strategy to really get people involved in the program. And the reason that I'm highlighting that is because when you're thinking about litigation, litigation is a powerful tool, but it's a limited tool. You can only sue on the basis of some legal right, some legal duty that's been defined. Maybe you need a statute to be passed that says XYZ is an illegal thing to do. In the Ferguson v. Jonah case, we had a consumer fraud claim. And so our sort of theory of liability is that you can't lie to people in order to get them to give you their money. And New Jersey has a consumer fraud law that says that. And Jonah, by making these medicalized, science-ized claims, was making itself into a comparatively soft target for a consumer fraud claim. Jonah put a lot of stuff in writing. They did a lot on their website. They sent a lot of emails. They created a lot of evidence of the fact that they were selling to people, what it was they were selling to people. And all of that made them a very attractive litigation target for this consumer fraud claim. So it was a kind of a first of its kind claim. And Tom is going to talk about this more in a minute. When you think about, you see a, let's say a cancer in your society, like conversion therapy, and you want to get rid of it. There are a lot of things that you can do to try and get rid of it. You can use legislation. You can raise awareness. You can try to change culture. Raising awareness is part of that, obviously. And you can try and litigate. And so Ferguson v. Jonah was part of this litigation strategy, first of its kind suit that said, okay, let's see if we can use the courts to address this from this consumer fraud angle. And one of the reasons that that's an interesting angle in this context, and folks may be having a reaction to that already, is that when you're thinking about therapy and you're thinking about conversion therapy and the communication around that and the culture around that, you're thinking a lot about speech, you're thinking a lot about religion, and those can be fields filled with landmines for litigators. Consumer fraud strips a lot of those problems away. So I don't want to get ahead of myself. Let me just tell you a little bit about this case because it is a very interesting case, and I assume I have 4 hours, so I'll be able to really fully get into it. But Ferguson v. Jonah, we had some really brave plaintiffs, former clients of Jonah, who came to Jonah as vulnerable young men asking for help. And instead they were shamed, blamed for not changing. I think that is the thing that makes me the most angry about what Jonah did. It did a lot of terrible things, but I think, at least this is personal to me, I think the worst thing you can tell somebody is that they're a bad person and that they're to blame, and create that feeling of self-hate and shame within them. So I'll tell you about some of Jonah's really awful practices, like having people reenact childhood sexual abuse, having people strip in front of their older therapists who claim to be ex-gay. There's a lot of predatory conduct by counselors. I think a lot of basically sexual abuse of the vulnerable clients. Having people go to these weekends in the woods where they would be isolated, their resources, their ties to whatever community they had taken away, and they're just alone. And then again, told by people to be naked, to put themselves into very vulnerable situations, to be touched in ways that, again, to me appear to be sexually predatory. Those were all terrible things. But then after inflicting all of those terrible things on people, and those people would come to their counselors in whom they were asked to repose trust and say, it's not working and I don't know what to do, to tell those people it's your fault because you're not trying hard enough, I think is the worst, the sort of capstone on all of it. So that actually brings me to the other thing that made Jonah such a soft target for litigation, which is that its practices were extreme. And in a way that's very colorful, it's very easy to explain. I think for some people, it can be really hard to explain just how damaging talk therapy can be. So I've just said that from my perspective, the most damaging thing that Jonah did was just speech, right? They told people, you have something to be ashamed of. It's your fault that you're not changing. That's just saying words to someone. And for people who, especially for people who aren't already persuaded that you're right, for people who aren't comfortable with homosexual desire, or aren't really very educated about conversion therapy and not inclined to think that it's a bad thing, it can be hard to explain why just speaking to somebody and saying terrible things is so damaging. It's a little easier to say, well, they had super young men go off into the woods, took their car keys away, asked them to stand blindfolded in the middle of a circle of older, purportedly ex-gay men with a blindfold on, and then instructed them to touch themselves on the genitals. That is something that I think even a lot of fairly homophobic people would say maybe shouldn't be happening. Or another colorful detail, Tom and I were just brainstorming what we thought our top 3 was, and this has always been on my top 3. There's a list of supplies for these weekends in the woods that we got in the case. And some of those supplies are very disturbing, like a fake headstone. But my favorite supply is a bucket. And the reason for the bucket is because people would become so upset that they would vomit during the exercises that they would do. So again, I think if we're thinking about trying to shift the conversation and persuade people that conversion therapy can be really damaging, for some people, you're able to have that kind of higher level intellectual conversation and talk about the damage that speech can do and the damage that these messages can do to young people, especially, and the high suicide rate. And then for other people, you can say, well, there's a vomit bucket and a blindfold on the equipment list. And what's going to happen is that people are going to be sexually exploited in ways that are sort of repulsive and disgusting. And in fact, one of the things that happened in our case is that the organization that runs these weekends in the woods, which was then known as People Can Change, now known as Brothers Road, came in and they said, these materials that describe what's going to happen at the weekends in the woods, they can't be made public. And they said, I was shocked actually that they said this in their motions openly, they said if people knew what we do, they wouldn't go and they wouldn't send their kids. And I agree. They said other things as well that were very silly. But that was something they said that was, I believe, what young people these days call telling on yourself. So that aspect of our litigation strategy, which was just to shine a light, then I think shone a light on some of these egregious practices that allow us to more compellingly tell the story of what's wrong with conversion therapy. I've wandered a little bit from just telling you about the case, and I'm sorry, it's very difficult because it's all so interesting. But so, okay, so we have these brave plaintiffs. We also had some 2 mothers of 2 of the plaintiffs who had paid for the services and who'd also been told made these false claims about the ability of Jonah to effect this kind of change. And they sued Jonah for consumer fraud, and then we litigated for 3 years. We went through basically cradle to grave, from filing the complaint to a full, almost 3-week jury trial. The jury was then out just long enough to eat their lunch and came back with a unanimous verdict that said Jonah was guilty of consumer fraud and of unconscionable business practices. And that was based on the testimony of each of our plaintiffs, who subjected themselves not just to discovery, which in litigation can be very intrusive, but also cross-examination in public on the witness stand. And there were reporters in the room who were hostile and who we knew were writing for outlets that have a very negative view of homosexual desire and who were trying to portray them in a negative light. I know at one point the lawyer for the other side went on the radio and said, I really love this. He wasn't saying that the lawyers representing the plaintiffs were possessed by the devil, but that definitely they were doing the devil's work, which I've never been accused of before, but found tremendously exciting. And then I spent the rest of the trial just waiting for him to say something like, I don't understand why counsel is arguing that, or something like that, so that I could say, I'm just doing what Satan wants. Like, don't take it up with him, right? But I never got that chance. But in any case, basically, in every other way except for the facts, it was like a vanilla litigation. We engaged in discovery, we went to trial, the plaintiffs were very brave, and I think because of their bravery and because of their testimony, they persuaded the jury, and everything else was just icing on the cake. We put forward expert evidence on conversion therapy and on how these particular weekends worked, and we got our victory. And there are a lot of uses for that in other parts of the overall anti-conversion therapy strategy. And like I said, Tom's going to talk about that. But for example, on experts, the defendants tried to put forward so-called experts to talk about how conversion therapy is actually good and effective. And that list of people they tried to put forward very much included people who go and testify in front of state legislatures and city councils and put themselves up in that context as well as experts, and try and persuade lawmakers not to restrict the ability of counselors to provide conversion therapy. So I quite enjoyed when the judge excluded them from being able to testify at our trial on the basis that they are not experts and have nothing to offer, and I believe said something along the lines of what they're offering is about as scientifically valid as the contention that the earth is flat. Which was an argument that one of our colleagues at the Southern Poverty Law Center generated, and involved us doing quite a lot of Googling about the quite vibrant Flat Earth Society. And now I know a lot about the theories about how that works, which is fascinating. One of them is an ice wall, a la Game of Thrones, but that is also a distraction. Bottom line, I'm fun at a cocktail party. So to round things out, I think our hope is that there will be more cases. But as I've suggested in the discussion of what made Jonah an attractive target and how all of that generates other uses, not everybody is the same kind of target for litigation. It depends on what kinds of statements you're making. It depends on what your conduct is. And I'm certainly not going to draw a roadmap for what I think a successful way to evade this kind of litigation would be for a conversion therapy shop. But I do think that every defendant is different, and not every defendant is equally vulnerable specifically to litigation strategy, which is why having a litigation strategy that's integrated with a larger overall strategy is so important. Which is my segue to Tom, but before I totally segue, I just want to apologize. I hope I didn't upset anyone. I was fairly graphic in what I described, and I see in the chat that I should have warned people that I was going to go there. And I wish I had been more thoughtful to do that. So I do really apologize if I went too far with that and I didn't warn people and then I upset them.
So one of the things that Lina touched on is that in a lot of ways, the Jonah litigation was not terribly different from the kinds of litigation that Lina and I deal with all the time. And it uses similar tools and has a similar purpose. And there are a lot of benefits to that, but there are also some drawbacks. One of the things that we spent a lot of time thinking about and were pushed pretty hard by the judge on is exactly what we were doing. Why are you in the courtroom today? Is this about these plaintiffs, these defendants, these practices, or is it something more? Is this, as our adversary suggested, the opening salvo in a global war on conversion therapy? And obviously, in some ways, it was intended to be, it was conceived as that. But in the courtroom, the limit is really the people that are in front of us and the issues that can be litigated by the parties. And so one of the things that we were really careful about is we don't need to prove in a litigation. And I think this is important for sort of strategic reasons. It's not about whether conversion therapy in all cases at all times could ever be successful, whether it is always by its definition a fraudulent business practice, whether there's no version of the kinds of services that the defendant sold that could ever be sold in a way that wasn't violative of the law. It was about what they did in these circumstances. And that's important from a litigation strategy perspective. You don't want to bite off more than you can chew. You don't want to set a goal for yourself that's beyond what you need to win the case. You want to set goals that are as modest as you can to get yourself to a win. Obviously, as lawyers, our number one obligation is to our clients. And so that's really the most important thing, to make sure that our clients' interests are vindicated. But that sets a bit of a limit, because we aren't taking on the global strategy. We aren't taking on all conversion therapy everywhere. We're not seeking a declaration from the court that conversion therapy as an institution is illegal. And that can, I think, feel a bit frustrating for people, especially in the conversion therapy, the anti-conversion therapy movement, because it's very incremental. It focuses on one group of people at a time. It doesn't have the same kind of broad reach that legislation can. And it's also, in a lot of ways, it's retrospective. We are stopping future harm, to be sure, but we're also focused on what's already been done and trying to make whole people who have been hurt and really harmed by the practices that we're shining a light on. And that can be, it can feel, I think, a little bit slow. It doesn't have the same kind of big, broad approach the legislation has. That said, there are some advantages, and I think litigation is a really important component of fighting conversion therapy. And I think maybe there are 3 reasons for that. The first, I think, as you'll hear today, legislation is subject to a lot of constitutional limits. So there are debates about whether you can have a ban on conversion therapy that goes beyond the provision of services from licensed professionals to minors or licensed professionals to adults. And that's because the state historically has a lot of power over protecting children, and they have a lot of power over regulating the conduct of professionals that they license. So it's a lot easier for a state legislature to pass a law that applies to doctors and licensed clinicians, maybe more challenging for the non-licensed professionals, which almost exclusively we dealt with in Ferguson v. Jonah. We dealt with people who decided they woke up one morning and they were going to be a life coach, and that was going to be an important thing. Something we didn't do, but I advocated for quite heavily, was I wanted all of us on the litigation team to become certified as life coaches during the scope of the trial, so that we could say at closing, by the way, during this trial, we all became life coaches. We're all life coaches. It's very important. But the point really is that in litigation, none of that matters. It's not about the conduct. It's not about the limits of the state to regulate conduct or protect particular areas of the populace. It's about generally applicable laws. And those laws have some benefits. Without turning this into a contracts law class, or maybe it was torts, I don't remember. Fraud has a lot of elements, some of which can be pretty difficult to prove. The one that I think is the most challenging in the conversion therapy space is intent. So for a lot of fraud claims, you have to prove that the person who lied to you knew they were lying when they lied to you. And I don't have any illusions that the majority of conversion therapy providers believe what they're selling. I really don't. But it can be difficult at the earliest stages of the litigation to establish that someone knew they were lying, to allege facts that are specific enough to convince a court that there's a reasonable probability that those people knew they were lying when they said what they said. And it's also unlikely in today's modern age, or maybe less likely in today's modern age, that there are the smoking gun emails you're going to find when you get into litigation, that you're going to find the email from the conversion therapy provider saying, haha, can you believe these people are buying all this snake oil? We're going to get rich. And so that can be very challenging. And so we were very fortunate in New Jersey that there's a consumer fraud law that doesn't require you to show that the person knew they were lying. It just has to be factually false as an objective matter. You can think you're telling the truth, and if you're wrong, you're still liable, because when you come into the public marketplace, you have an obligation to tell the truth and to verify that everything that you're saying is true and accurate. Maybe the third limitation on litigation, or the way that I think it is important but also has some drawbacks, is, again, what Lina was saying, which is you have to fit the facts into the law. You have to find a law that is broken in order to go after these people. And there are some states that are kind of pushing toward a more inclusive legal structure, that are trying to amend their consumer fraud statutes to make it clearer that conversion therapy constitutes consumer fraud. I think that would be great. I would love for more states to do that. In the absence of that, we really do have to look to these pre-existing legal structures and try to fit in the conduct that we've seen into those causes of action. And that can be difficult. As Lina said, I'm not going to talk much about exactly how you could make it more difficult, because that doesn't seem to help anybody on this call. But it is important. There are, and we have seen, we saw at the time that Jonah was filed, we've seen in the years since, that conversion therapy providers are becoming more strategic. They are being a lot more thoughtful about how they present their services, what they call themselves, what they do, how they market to people, how the hoops that people have to jump through to get into the door of a conversion therapy organization, to prevent people like me from pretending that I want to get conversion therapy and bringing a tape recorder into a meeting and using that to sue them. And so as the perpetrators of these frauds get more wily, or as we go into court and sort of start to set the boundaries of this is okay, this is not okay, we run the risk of explaining through efforts where litigation isn't successful, explaining through failed conversion therapy litigation where the line is. And so you really run the risk of wanting to go out, wanting to avoid creating a situation where you can look at a case, you can look at a decision by a judge and say, oh, okay, as long as I do this, 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 and this, I'm fine. They can't sue me because here's a decision from this court saying that's not actionable. And that's a risk where litigators, Lina and I are, and we deal with that all the time. We make calculated decisions. But what that sometimes can do from the litigation perspective is it makes you want to go look after the real obvious cases, the ones that are way on the outside of the line, because the risk of that adverse outcome is much lower. There's no shame in that, but it doesn't as effectively target the people who are maybe closer to the line of what is actionable versus not actionable, because again, you don't want to run the risk of creating a roadmap for people to learn how to create and to prosecute a really smart conversion therapy organization. And so I think that's where the legislative efforts become so important. And also where it becomes important to talk and to think about how we act as a community, and to look at, as Lina said, the kinds of communities that conversion therapy organizations target. There's a reason that they go after the most conservative, religious, insular communities, because that's where the fear of being gay and the fear of having to look at this life that you know nothing about and you're told from your family and your culture is deadly and will lead you to be an outcast. And so maybe the last thing I'll say about where we fit into this is it's also important to remember that there is, we set up, and in litigation, we benefit from kind of the absurd opposite. So a lot of times we present these dichotomies. There's choice A and choice B. And look how bad and wild choice A is. And that's really a rhetorical device that we use and can be very effective. But it's important that we not lose sight of the fact that there are real challenges for people who are experiencing same-sex attraction, they feel gay, they're experiencing attraction to people of the same sex or gender. And that's confusing, and it can be scary, particularly if you don't come from a community or a family where that behavior, those feelings, that emotional connection is normalized. And so people need to find a safe and healthy way to address, to process, to understand what they're feeling, and to find a way to see if they can have both of those things coexist, that they can experience their authentic sexual identity without sacrificing or compromising their cultural, religious, spiritual, cultural identity. Those are hard questions. And it's important to remember that there's a spectrum, and it's not all sue them or it's exactly what we want. There's a middle ground there. And I think thankfully in our case, we were able to really effectively show that there are resources for people who are experiencing the really very real conflict between their identities as defined by their culture, by their religion, by their community, and their sexual identity. And so that was, I think, a very effective tool to rebut the idea that the defendants come along with, which is there's nowhere else for them to go. This is their only place. And so I think as we look toward legislative efforts and community outreach efforts, it's important to think about where that middle ground is as well.